Okay, Kim, how are you?
Hi, good, Andrew. I don't know about these new chairs. I can't touch the floor.
I know, it's a bit like a travel in business class that time, wasn't it? Still nice feeling, comfy chair. All right, well, we've got lots on. What I was going to say, it's interesting, you weren't on last week, Nina was, and we talked about people using investigations. Sorry, this is something without notice, using investigations as a control and safety law. And we've just seen Minefield, which is a very large organisation that's been alleged, some pretty horrible things have been alleged against the organisation. But once again, they've gone and appointed a Silk as an investigator to try and stop the noise that's going on. And we saw this not that long ago with Channel 9 doing exactly the same thing. And I guess for all those organisations who think it's a good idea, can you just not do it? Because it's not a control at all. It is actually part of the risk assessment, and reasonably practicably you identify the hazard. Merivale's had a myriad of hazards raised, particularly for their priority room. So how do I assess what is the level of risk? Well, that's actually where the investigation goes. But now they've made public, they're making an investigation. The public and everybody who is involved will want to understand what is the outcome of that. And then comes the controls. And so they're creating a rod for their back, and this is a communications issue where communications people say, well, why don't you say you're investigating? Well, all you're doing is creating dedicated evidence to blow it up. Whereas what should have happened is a long time ago, when the first snippet of risk came out, an investigation should have been undertaken, an action taken, and then they'd have control over the media. But instead of that, they've waited till it's blown up in the media, and everybody knows reading it, the only reason they've appointed an investigator is to kill the noise. But the people who are going to bring the claims now know there is an investigation report. And there's a series of cases that say, even if it's underprivileged, the findings in respect of them or that relate to them are therefore findings they're entitled to receive. So they're in trouble, just like Channel 9 are in trouble for thinking it's a clever, cunning communications stunt to do an investigation as a control. It's not a control, it's just unzipping the problem. Anyway, I just thought I'd raise that. Sorry, I didn't give you much warning.
That's
but
all right.
We talked about it last week, and I thought best we talk about it again because it's happened once more. Let's go to Ventia. Look, so this is an interesting case, and again, both Kim, Nina, and I have been talking for weeks about how the Fair Work Commission is being much more careful about the nature of evidence investigations and the fairness process. This was a guy who went out to lunch with somebody who was a potential competitor.
No. Current employee had lunch with a former employee, and as a result of that lunch, the former employee emailed competitors and said, I've just caught up with such and such, and I've got some information about the company. That email came back to the company. The company thought, he's disclosed confidential information to this guy during their lunch.
But they never spoke to the person who was the manager at all. No, the manager. They never spoke to the person who sent the emails out.
No, that's right, the former employee.
So all they had is an email, which is clear hearsay. It is what somebody says somebody said. And on that basis of that email, they terminated their employee. Now, they terminated for two reasons. One was they felt the employee wasn't being candid, but by the time they got to him, a month had elapsed. So it was a bit of time. And the Deputy President said, look, a month's a fair period of time, but yes, there's some erosion of trust by the FA, to be clear, but the complete lack of fairness in the process by the use of hearsay evidence, the failure to actually interview means might have been a valid reason, but it's certainly not fair. So again, I think because we see investigations and we run investigations every week, we see this idea of somebody becoming sensitised to a piece of behaviour and wanting an outcome and trying to shape the investigation to give the outcome. Usually if someone's not a good person, the investigation brings that out. You don't have to be scared about it. You don't have to try and manipulate it to get what you want to do. But every time you break a rule of evidence collection, you will be criticised by the Fair Work Commission. And I guess in the Fair Work Commission, hearsay evidence is admissible, but it's given a particular weight based on the fact that it's not as reliable as direct evidence. In investigations, direct evidence is king. That's where you go. It's what somebody said, did, heard, That's absolutely critical.
And that's why you can keep contemporaneous notes.
That's exactly
during
right.
Any disciplinary
and as I've
process.
said before, contemporaneous notes are admissible as the truth of what occurs for you as the investigator. But remember, don't cut corners in an investigation. It might cost you an extra $3,000 or $4,000 or cost you an extra couple of days, but just don't
It's
do
not
it.
worth it.
Yeah, it's not worth it.
This case was ordered to pay 25 grand, so it puts that in perspective too, doesn't it?
Yeah, and the truth is, the only reason why he wasn't reinstated was there was said to be a bit of an erosion of trust because he wasn't completely candid. Safety concerns trumping cross picket lines. This is a misconceived case where the wrong application was made, where an application was made to force subcontractors' employees to cross CFMEU picket lines. Okay? And there is almost no evidence as to the nature of the reasons why they didn't cross. Obviously, the picket line's a pretty obvious one. But the evidence that did come out suggested the subcontractors were not failing to direct people to go to work. What they were saying is we have safety concerns for our employees should they cross the picket lines. So the obvious application was to stop the picket lines because they were they were no longer protected because of the nature of the threat that they posed. And there was evidence there of the nature of the threat through the actions of the CFMEU, but nobody did that. In the old days, what we used to do is we used to get the subcontractors and we'd line them up at a shopping centre and we'd stick them on buses and we'd organise the police to arrive and they'd go through the picket line. And that would be testing the picket line for the breach. But none of those better industrial behaviours were undertaken to test the picket line, and instead they tried to coerce the subcontractors and it failed. So for anyone who's got picket lines, there is a process you use to test the picket line, but you don't throw it back on subcontractors and people to cross that line because you'll always get the argument that it's not safe, but you won't have enough evidence to stop the picket line. So you've got to test the picket line. Okay, interesting case. What do we got next? I think we've got drugs in Sydney trains.
So we've got here a guy who failed a drug test. They found traces of cocaine in his system and he was terminated. He lodged a Fair Work Commission unfair dismissal complaint. And then on appeal, the employer
I think it's worth saying at first instance they said, well, there's no evidence of impairment.
That's right.
Yeah, and
you had to find evidence of impairment, and that was the appeal point.
Yeah, and so it came up to the appeal, and what the appeal looked at and said, well, the presence of drugs may be a valid reason, full stop. But then you go to the fairness all-round test that sits in there, and the question is, impairment is one of a number of tests that you go to, but it could also cause reputational damage. It could cause a whole
safety risks,
all sorts of things. But the evidence wasn't there around any of those issues. They'd got stuck with the impairment issue as being a key issue, and Sydney Trains was saying impairment isn't the test, but they forgot, well, actually, there's a number of different issues that you need to agitate and address. So employees been reinstated. So you see today, one of the themes we're saying is don't rush to litigate, is my point. And when you do, look broadly at what the issues will be and what are agitated. And we've seen 2 or 3 cases here where wrong applications have been made, where the wrong issues are being agitated. Yeah, lawyers are expensive. I know that. I'm one of them. So we're expensive. But remember, lawyers are also linear too. So they will prosecute a case based on what they think is the best option. But you as an employer must agitate all the risks. You must come and say, well, look, I know you want to do that, but these are the other things that really matter to us, and try and get a broad compass of what is the risk you're managing, because the Fair Work Commission is interested in fairness. And it wants to look at a number of factors, not just one factor. It won't be drawn to that unless it's compelling. So I think it's a really interesting case, and it goes to the drug and alcohol cases we've talked about before. All right, blaming a company. Don't you like this one? So this is a very simple case, and it's a fun case because it's a guy who's raised complaints about his bonus, who's a manager. He's raised about his workload. There's no real evidence for all that sort of stuff. He's sacked because of his outrageous behaviour towards other people. He brings a general protections claim and says, look, nobody addressed my issues, my workplace rights that I raised, and as a result of that, I shouldn't have been terminated, and I deserve some damages. I just love industrial lawyers and industrial commissions, and in this case, I think it was a federal court, wasn't it? Ended up in the federal court. they're so practical because they just said, look, I know you raised it, but where's the evidence of it?
Yeah.
You know, take us to the evidence. And of course, it was just nothing. And again, I mean, we don't act for plaintiffs. And one of the reasons we don't act for plaintiffs is this case, okay? Because people have such a deep sense of grievance and it's based on assumptions and perceptions. Courts deal with evidence.
And the evidence in this case was he was a shocking manager.
Yeah, shocking manager. Yeah. But how many shocking managers we know who we eventually terminate, who always feel that the world is against them? So for us, remember, document as we go through. This is a case where the business documentation was clean, precise, accurate, substantial. His was assumptive, impressionistic, and angry. And he lost. So really good lessons. I know it's not a world-leading case, it's not a precedent, but I think it's a really good reminder. And McAllister and Ahoy.
I like this one too.
This is a captain of a charter boat who left the place to go and chat to people, was vaping,
was on his phone,
ignored the rules around managing where he was coming into the channel. They ran into a channel marker, could have crushed a deckhand. His argument, I think, was unique, which is he mightn't have followed any other policies, but he did follow the policy about keeping people happy.
I had to talk to the passengers when they were.
And I just thought, you could try a bit harder, couldn't you say you were never taught the other rules or something? It was terrible. I mean, he had none of the rules of safety complied with. And he ran into something. And his idea was trying to keep people happy. I guarantee you, they weren't happy about running into a marker.
No.
I think
causing 150 grand damage to the boat. Anyway, I just love some claims that people bring.
I mean, you guess he was unsuccessful. Yeah. Okay, now I think this is it's a lifeguarding company that acted for a council and undertook to provide services of lifeguarding, which was 2 people present at the pool when there were people there. Not surprisingly, costs and things became a bit of an issue, and so they calibrated on the number of people who were in the pool. Father and son Chinese tourists drowned in the deep end of the pool, got into trouble. There was no one there to save them. And the fines were $300,000, but part of those fines went directly against the director of the lifeguarding business for not doing the diligent thing, and Section 27 is the due diligence obligations, of providing appropriate safety given the knowledge of risk and given the fact that their original policy and process demonstrated how to manage that risk. So he was liable, or he or she was liable for that breach. And I raise this now because there is a raft of people who think you can just sneak by on safety. In here, there are life-saving standards that exist about what is appropriate.
Which they ignored.
Yeah, and remember, for what is a hazard is what is known throughout an industry. So if an industry has established rules, you can't just ignore it, you can't change it, unless you can demonstrate that your method of getting around that creates a safe environment as well. So you can move away from Australian standards. You can walk away from WorkSafe guidelines and codes if you want to, but you must be able to evidence that the management of the risk you've done is everything that is reasonably practical, even if it's not adopting theirs. Here, this is purely financial. So $300,000 fine, lower end of the fines, given the serious nature of what occurred. They are incredibly fortunate. But it again shows this willingness of the regulator to prosecute individuals. And I think for officers, this is startling. This is about the 15th case of officer prosecution this year. We know that's on a trend upwards, and the WorkSafe regulator director got up very recently and said, we need to prosecute more, and we need to prosecute more individuals to get leverage. So here's a case where it just happened recently. Okay. What have we got next, Kim?
I've got a main topic, but first we've got a case that leads into it about a lady who was working from home.
The pet fence case.
Yeah. She set up a barrier into the entrance to her office to separate her puppy
and the rabbit.
And getting up during an authorised coffee break, she tripped over the fence and injured her shoulder and knee, and her employer said, no, we're not liable for this.
And I just want to say to you, what is an authorised? How do you know an authorised break? I know I'm starting this argument early.
A bit early,
but Really?
Yeah.
Anyway, compensable.
Anyway, her claim was compensable because employers aren't expected to know everything.
Yeah.
And she got away with it.
Yeah, then I mean the reality is workers' compensation is not a causation based.
No fault.
So it's no fault. It doesn't matter how. I think there was a Chief Justice in New South Wales who said safety law is about stopping stupid people doing stupid things. Workers' compensation is just, it doesn't matter if they get injured and they're at work.
Yeah.
That's it.
Doesn't matter how stupid they were.
Doesn't matter how stupid they were. They can be chaotically stupid. Unless they intentionally do the wrong thing and harm themselves as a result of that, you have no way out. And we both thought this is a funny case, didn't we? And we thought, well, it really does show what the level of risk is. But I guess my level of risk from dealing with half a dozen employers who are really struggling with flexible work at the moment is this. We have not been courageous enough to describe what is flexible work in a manner which meets safety law, employment law, and workers' compensation law. So the classic issue of someone working from home, we don't want to be watching keystrokes. Okay, I know there's some insurance companies who've done that, which is sort of predatory and stupid and erodes trust. But when you allow people to work from home, you don't know what the safety of the house is that day. Yeah, we look for safety law. We require people to take photos, do a risk assessment. Everyone should do that as an absolute minimum. Make sure the office space is a dedicated space that's cleared from things. But my dog comes and sits under my feet. I've still tripped over my dog on the way out. So there's all these levels of risk which we don't have at work. So that's one issue. We've got safety law issues about workers' compensation. But this is a flow-on from COVID where people arrange their lives around working virtually. So people are going to doctor's appointments. People are going out for a walk rather than having a coffee. They go out for a walk, go and buy a coffee down the road. They're still on compensation at this stage, by the way. So,
that's right.
So all the things they're doing are all things that they don't do at work. And on top of that, because they're not working 2 or 3 of the hours a day, they're catching up. Because people are good. People are not trying to be tricky and get out of work. But instead of that, they're working outside ordinary hours. And under all awards, when they do that, there's penalties and loadings that come in on that. And so what we're creating is this sort of minefield around what is work, because work at home is not work at work. Work at work is you come to work, you work a number of hours. If you're a lawyer, you keep working and working and working. But if you're not a lawyer, then you go home. But at work, there is a dedicated commitment to being at work. But our own experience as a firm and as acting for people is that's not what is happening. So 2 or 3 times in the last 2 or 3 months, I've tried to reach somebody and they've rung me back and said, look, I was just offered a dentist. And I knew nothing about it. Now, I know because awards don't attach to the lawyers, that's not such an issue to me. But I did say to the people, look, these are working hours. If you're going to do this, let us know so I prove it. But if they're an award-based employee, I know that that's kicked into overtime. I know that's kicked other issues into play. So I guess the reason Kim and I are raising it is when we spoke about it, both of us thought, everyone's so reluctant to talk about this. Everyone is saying, no, let's not have this fight because people are tense. It's very hard to recruit people. Flexible work is now an essential part of recruiting people. But the answer is, what's wrong with just telling people the truth and saying, look, let's talk and recalibrate working from home. Working from home has these safety assessment processes which must be carried out. How many businesses are now doing safety assessments like we did? Almost none. It does require being on and being available between the working hours. Okay? It does require you taking, to take breaks at the time breaks, because everyone's work is around the expectation that everyone is available during particular times. That's why breaks occur at a particular time. But if you don't do that, your exposure is not just workers' compensation, although that exposure is high, and we're going to give you a problem which shows how difficult it is to determine whether it is compensable or not in some circumstances. Your safety risks are high, and we've already had safety prosecutions around it. Your employment law risks are massive. And then comes the question of, well, can a person who's worked flexibly then switch off at 6 o'clock and say, don't connect with me, even though they haven't done their work? Because you've condoned a work practice that allows people to work less than their usual hours. You've allowed people to start at 9:30. You've allowed people to go out to doctor's appointments, catch up with coffee for friends. You've allowed them to drop their kids off at school picnic. You've allowed them to do it, but it means they're no longer working 8 hours or 7.6 hours. They're actually working 5, but you've permitted it.
Yeah.
So can they then, when they haven't finished their work at the end of the day and you chase them up and say, look, those 2 documents haven't come through, they can ignore it and say, oh, I don't have to return this call.
Well, that becomes a performance issue then, I suppose.
Well, it does, but the issue is you've already created a contract that's different. You know, under Cosma and Qantas, if you've been letting someone work 5 hours a day for a year and a half, with all those interruptions and expectations, it's very hard to recalibrate and say, well, no, you're meant to work 8 hours. Now, a court's going to go, of course you're meant to work 8 hours, but it's going to be a nasty fight. And it's one you should never have had, and you've lost a year and a half's production. So I guess my point about all this, Kim, is I'd like the people just to go back to basics, which is if you're working flexibly, re-agitate what flexible work looks like, because now most people are doing what they feel like when they're working from home.
So there should be policies in place for working
Not
from
only
home,
policies, but a real
consultation and
real agitation with people, what expectations are, and a reminder of those expectations. Regular catch-ups, all the stuff we did in COVID to maintain relationships has gone by the wayside. And so the catch-ups that were so much part of integrating people and keeping people connected have also gone, but the practice is still there. So I think it's time for a refresh. Anyway, why don't we try the case study, which I wrote. This is a short one for once.
It is short, but it's funny. Okay, Pete loved the post-COVID world. These days he worked from home 3 out of 5 days. His role as an online sales representative for a tech business fit perfectly with working from home. As a self-confessed tech geek, he eschewed frequent contact with people and social gatherings. He was also a gamer in his spare time and he loved it, particularly Valorant?
Yeah, Valorant.
Which he achieved radiant status, the top level.
Only
Is there such a thing? Or did you make that up?
No, only 500 people in the world have that status.
How do you know that? Anyway, conversation for later. He arranged his life around looking after his 2 pet dogs, picking up his girlfriend from university, and doing all his household chores and medical appointments at convenient times during the day. But he always hit his KPIs, often working late into the night. He and his girlfriend, Little Rock, her gamer nickname, had a gaming room next to his study where he worked from home. He would often take a lunch break or coffee break in the gaming room, preparing for the midnight fights online. One day he tripped over a cord connecting his work laptop to the internet in the gaming room and injured his knee. Although it was 3 p.m, a work time, he was leaving the gaming room after a coffee when he tripped.
All right, so what's our first question? Is there any employment law risk? Can you see that just jumps up? Here's a guy who's clearly an award-based employee.
Yeah.
So he's working outside of ordinary hours. He's entitled to penalties. And you're allowing somebody, he hits his KPIs, but nobody else can contact him at relevant times. He's not connected inside the business in a way that, so the employment law risk is clearly award breach. Okay. Is it okay during working hours while working from home to do home-related tasks, arrange medical, not work? No, it's absolutely not. But it is constant. We hear about this. There wouldn't be 1 in every 5 conversations I'd be having with people when I visit them is talking about the problems they're having with people working flexibly on these issues. Now, question, is his injury compensable?
Okay, so it depends. If he was working prior and he'd gone into the gaming room to have a little coffee break and then he was heading back to work, absolutely it would be compensable. If he hadn't logged on or wasn't working immediately prior, even if he was heading back to do work, I don't think it would have been. So
here's the rub. What about if he says, look, my work hours are 9 to 5, it happened at 3 o'clock. So I was definitely in my working hours.
Still won't matter. They will look at the circumstances of what he was doing either side.
Well, that's nice to know that. Well, what do we got for next? Safety law? Well, can we just be clear about safety law? Where a person's work environment is and where they access or go during working times is part of a workplace. So your kitchen is part of a workplace if you're regularly going to kitchen and having. Do you see why working from home is so complex? This was not safe. It had a tripping hazard. Yes, the tripping hazard is relatively low in terms of high risk activity, but it's clearly a breach of safety law.
And for him, what would concern me is the fatigue management. If he's seeing daylight on the days that he's not at work, is he getting any activity at all?
Yeah.
They're all things that an employer has to manage as well.
Yeah, and remember, part of a risk analysis is the people you're dealing with. So I was up in a rural community yesterday talking about high risk activity where farmers are part of organisations and they come and help for free. Okay. And I said to them, you do understand the risk appetite for people in rural communities is much lower. They don't care. They're so desensitised to risk, but they're driving tractors onto a site which are not safe plant, doing non-safe things with no risk analysis. So it comes back, one of the biggest risks you've got to think about is what are the people that are doing the work? So it goes into your assessment of risk. If someone's repeatedly doing gaming, working late at night, working chaotic hours, you'd see their chaotic hours. Fatigue is a real issue, which means the likelihood of injury from tripping increases much higher. So you're right. That's a good point. Employment law, what must you do? I think we've really pushed this home, but I want to push it again. It is time for refresh for all organisations to say, do my contracts quite properly connect with my policies and the behaviours that come out of it? Are people doing things around flexible work which aren't flexible work for the purposes of the Fair Work Act? In other words, carers leave, looking after whatever it is, where there is a particular process. Can you clean it up? Can you go through and do an audit on what you're doing and go, okay, flexible work, we need a letter. Is there a business reason to say no? Is there people with long established behaviours which are not, okay, we need to do a reset, but we understand that there could be some risks. But be clear about what is working from home. It is actually working. It's not doing work when you feel like it. It's not do work when you feel, I can't do all the letters together, do work when you feel like it, work from home. It is actually, you're running a business and businesses require a commitment of a period of time so that everybody can communicate and execute work in a coherent way. As everyone starts working different hours, that falls down. So the quality drops off, deadlines drop off, but most of all, people aren't part of a team delivering coherent, clear advice. So you lose all the institutional knowledge that sits in there as well, as people just do their piece rather than understand what Kim's doing, what Nina's doing, what anyone else is doing. And I just put the last question about disconnect down for the question I raised earlier. Just say he hasn't finished his work and his employer's starting to worry because he's only done a couple of hours work, and the employer rings him at 6 going, hey, Pete, what's going on? And sends him an email. Can Pete ignore that? Yeah, and if they act upon his failure to respond, well, then it's a general protections claim. So there's this little sting in the tail around the right to disconnect. It's not a big issue, but it's alive because when people are working at night time, the issue is how do you actually manage someone who's not working during normal hours? Do you start managing them at night time, and what is the risk that comes with that? So there, mate, that's just an interesting problem. Well, it's very relaxing and sitting back. It is like actually. Yeah, I quite like it. Except my nose gets longer as I come forward. Now, great to have you here. Good to see you. Thumbs up for us. Thank you. We need a bit of thumbs up and enjoy. See you later. Bye-bye.